meeting to order, 9 a.m. Thursday, October 31, 2019, Policy and Procedure Committee. Call the roll, please.
Behrens.
Here.
Alt.
Here.
McTaggart. Awful. Here. Signot.
Here.
Sure.
Yep. Is there a motion to approve the agenda?
So moved.
Is there a second? Mr. Alt, all in favor, aye?
Aye.
Opposed, same sign. Public comments. No public here. Committee chair reports, Mr. Sticknall. Tax and zoning committee.
As far as I know, it'll be the standard department head reports. That's all I've got so far.
Mr. Alt, finance,
Mr. Moore.
highway.
Mr. Moore kept it a secret. He wants to deliver his report right now.
The only thing we've got besides ordinary bills is, we do have a resolution, for, matching tax for the Woodland Bridge that we need to present to the state, so, we can proceed with letting them know.
Finance,
I don't know a thing about finance. The chairman's not here. I knew that.
who's the vice chairman?
He's here.
Mr. Behrens, management and judicial.
Management, we're gonna be talking about the same things we've been talking about the last 3-4 months. Judicial standard reports.
Mr. Lawful, health,
We will be regular meeting reports.
and the ordinance updates for the cats.
Yes, we'll be working on that.
Okay. We'll move on to the EMA report, Mr. Sacy.
Real quick report today. Over the past month, the majority of my time has been spent working on the hazard mitigation plan for the county and the county's emergency operations plan. I expect to turn that in today. Besides that, EMA assisted with a Tunnels to Towers event by just providing a little bit of traffic control, and participated with EMA, the health department, and the local amateur radio club participated in a communications exercise that was statewide this past weekend called Fractured Prairie. The idea was all normal communications were completely knocked out, so how do you communicate amongst yourselves and with the State Emergency Operations Center using amateur radio communications? So we were able to do that and test out some of our equipment, and it worked out. We found some deficiencies, but that's what exercises are for, and it was a good learning experience. And I've attended numerous meetings, but I don't have them listed for you, so we'll just skip that part. Over the next month, I'll continue work on the mitigation plan. We get that wrapped up for the county, or at least proceeded to the next step. And no more business. Any questions? Thank you.
Okay, next we got an update on the flood matters in Iroquois County. Pass this along, please. There's been quite a bit of things that have gone on over the past month, so I prepared a summary of most of them. And I'll just run down. First one being the Iroquois County Water Conservancy District, which we're working on getting into place. It's an area that includes the townships of Concord, Belmont, Middleport, and Iroquois. And it also includes the area 1 mile on either side of the river going north from Iroquois Township up to the Kankakee County border. The petitions for this that were circulated by various individuals have been submitted to Judge Ginsler. There's a hearing that's scheduled for December 2nd at 1:30 p.m. at the courthouse. And the county clerk has been working on the ballot preparations for the voters in the proposed district. That's kind of the status of that project at the moment. Kankakee County, their petitions are also been in place. They're they're annexing onto the existing KRVC of Illinois, which goes from the Indiana border to the town of Momence. I have a map here, just in case anybody wishes to look at it. This is what the Kankakee district will look like, presuming it's approved as being presently proposed. So if anybody wants to take a peek at that, they're welcome to do so. On October 17th, there was a log jam that's been there for quite some time at the State Line Bridge that was removed. That worked out very well. The contractor that was brought in, those expenses were paid for by Indiana, but the contractor that came in had some amphibious equipment, and it worked out very, very well as far as the whole process is concerned. All the logs that were removed will ultimately be burned. I guess they're trying to get them to dry out a little bit right now before they run through that process. On October 21st, I attended a meeting of the Technical Advisory Committee over in Knox, Indiana, and October 24th, I attended a meeting of the KRVC, YRVC Commission meeting in Crown Point, Indiana. That's the commission that myself and Chairman Wheeler from Kankakee County are part of. On October 25th, and this is pretty significant, the Indiana State Budget Committee authorized the release of $2.3 million to fund the work of the KRVC and the YRVC. There's an attachment on the back of your paper here that provides further information about that and the press release and so forth. So I think everybody involved is very pleased to see that happening. That along with the next one on October 29th, where Jasper County passed a special assessment to match the FEMA grant that they have for bank stabilization along the Kankakee River in Jasper County. It's evident that people in Indiana are moving forward very aggressively. So the onus is going to be upon us in Illinois and in Iroquois County and Kankakee County to do our part in this whole matter of trying to improve the flood situation. So that's kind of where we're at with all that. There'll be obviously more things going on continuously. I might point out that at the meeting on October 21st, one of the main things they talked about was the removal of trees and log jams. And they estimate in Indiana there's 10,000 trees that are in the river over there. That's a huge amount of trees that has to be removed. And to that end, I did get an email that I just looked at earlier this morning from that people, the surveyors in Stark County, I can't remember the other county, I think it's LaPorte County, had put out a request for a proposal, and they have a map, they've identified numerous locations for tree removal, so they'll be getting bids from contractors on those. That'll ultimately be approved, something that'll be approved, the money and so forth over the coming months. I would expect sometime in the spring is when that work might start, but it could be even sooner, I guess. But point is, there's a lot of activity going on over there right now, and as I said, I think the onus is upon us to pick up the ball and move with it. So that's where we're at. Anybody have any questions about that, any of that, or any comments? Okay, we'll move on to the next one, County Board Portrait. This is a reminder that on November 12th, the County Board meeting will be taking pictures. The plan right now is that prior to the meeting, myself, Lyle Behrens, Lisa Fancher, Brian Suber, and Amanda Longfellow will have their pictures taken, and then during the conduct of the meeting, we'll go probably in alphabetical order with the board members to go in next door to the break room and have their pictures taken. If it works out that we can start some of it even before the meeting, I guess there's no reason we won't follow that procedure as well, but that's basically the plan we'll have a sheet prepared ahead of time listing everybody's name in alphabetical order, so everybody should know who they go with, who they follow in to get their pictures taken and so forth. Anybody have any questions about any of that?
Sometimes I have to leave early to go to work, so.
Well,
And I'm home.
I don't think you should have any problems. I mean, it doesn't take that long to get the picture done. I would think by 9:30 or so, we got to be completely with it, but 10 o'clock for absolute. Unless somebody breaks the camera.
Probably you.
What? Okay, next one is the 2020 meeting and holiday calendar. Do you have a copy of that for everyone to look at? This is something in years past, every November P&P meeting, we always go over the calendar for the coming year.
On those sheets, you've got one side is the county board meetings, and the other side is the holiday schedule, and so it's two separate resolutions to approve those.
You can see all the county board meetings are scheduled to be held on a Tuesday at 9 a.m., which is our normal meeting time, and normal second Tuesday of the month, so there shouldn't be any issues there. I don't know that there's anything unusual or out of line with the holidays either. Need a motion to approve this and send it on to the full board.
So moved.
Do you need two separate motions? One for the holidays, one for the meetings?
I move that we approve the meeting schedule for the meeting schedule.
Okay, seconded.
And this is for the calendar year, not
For the
not
calendar
the
year.
fiscal year.
Calendar year 2020.
Yes. All those in favor say aye.
Aye.
Opposed, same sign. That motion passes.
And I move that we approve the holiday calendar for the calendar year 2020.
Seconded by Mr. O. All those in favor, aye.
Aye.
Opposed, same sign. That motion carries. Over the past month, we have received an invoice from an organization called Illinois Association of County Board Members and Commissioners. This is an organization that I guess mirrors in many respects the UCCI organization that we work with. Apparently, and I don't know all the history on this, but apparently we did pay dues to these people in the past. Last time was in 2013. I don't recall that we've received any invoice from them since that time, but lo and behold, it is one that came the other day. So we need to think about it, decide what we want to do.
What exactly do they do? What is this about?
Well, I think they, as I said, I think they mirror the UCCI in many respects. I'm sure there may be some information that they have that UCCI doesn't have, or vice versa. They have a website. Anybody can go on their website and research any of the things that they put together. As I said, I think the fact that we last paid these dues in 2013 would be indicative of the fact that maybe we don't want to do it, but I feel we're obligated to think about it and look at it and so forth. One thing about it too, with UCCI, we pay dues to them of $1,500 every year, but every year they refunded that at some point during the year. They're not under any obligation to refund the dues, but their finances have been such that that's what they've done. So I asked, since it doesn't cost us anything for that membership. And they're the ones that, for example, the trip that, when we went to Washington in mid-September, UCCI paid $2,500 for that. It was for the expenses for myself and McGinnis. And the year ago, the same thing. And then Chad's been going to some of their meetings, and they pay all of his expenses to go to those meetings. So it doesn't cost us anything at all for that. I don't have any idea what we get here, but I just don't, like I said, I feel obligated for us to look at it, but I don't know that there's anything that we need to do with it. And we do get information all the time from UCCI. We get a lot of emails. Some of them come to Lisa Fancher, and she forwards on us. Some come to us. We get mail that comes from, we got, I think, something here in the correspondence today from them as well. So, anybody have any thoughts?
Well, if we don't do anything with that, then it keeps billing us.
I'm not sure if they will or not. It remains to be seen. This is the first time, as I said, the first time I've seen a bill since I've been around here. Although I was here in 2013, but I don't recall why it was that we paid it. I believe it was not too long after that we started working closely with UCCI, wasn't it? Do you remember, Amanda?
I'm not sure. I've never heard of them before.
I know it was somewhere shortly after that when we got those red handbooks from UCCI and some of the other activities that we were involved with. As far as I know, we had not ever had that before. So,
Oh, can someone call about that and find out what it's about?
I suppose we can do that. Again, I don't know.
I mean, I don't think we need to pay something we don't know what it's about.
Well, I'm not advocating that we should pay it. I'm only saying I feel obligated to bring it before the committee. Can't just throw it in the garbage.
I doubt that we should really take any action.
I'm sorry, what you say?
I doubt that we should take any action.
I guess I kind of follow that same line of thought, and I would have thought, with sending this invoice, they might have at least accompanied it by some kind of a letter explaining why we should pay it, what the benefits are, and so forth, and that's not what happened.
Just anybody can send a letter.
So,
Say you owe this.
it's good to send invoices, sometimes people pay it. Anybody else have any thoughts? I'll look into it tomorrow. We can hang out to it. We don't need to do anything with it today necessarily. We also got another thing that kind of puzzled me a little bit. We got a letter from the Department of Agriculture. You remember we had those hearings here about the Parks swine facility. So I'll pass this around for you to review. I really don't even understand exactly what their letter says, because it says that they more than likely not have met all the requirements, but they also tell them not to begin any construction. Have they begun any construction that you know of, Marlon?
I have none. None has happened. Nothing has happened.
And this is for E4, this letter is for E4. Nothing we've gotten for E5 or E6. So, I just don't understand the language when they say that more than likely not, they have that, in other words, we're not really sure. When will they be sure? Why did they send a letter? Confusing to me. I guess, however, at this point, there really isn't any action that we need to take on it. It's more, bringing it forward for information. Possibility that there may be some further development, which I'm not sure what it would be or when it would be. Sounds to me like maybe there is something that needs to be figured out yet.
Evidently.
Again, if you want, I suppose we can contact the Department of Ag and see if we can get some more information on it. It's just, to me, kind of confusing the way they put that together, so.
What'd you get up?
Well, it doesn't say it's been denied. These are just, maybe things are still in process. And they may still just have to meet a few things, it's not real clear as to what hasn't been met or what needs to be met. But then it does say upon completion that they have to notify, so it's not a no. That I would say,
I don't recall that when we approved the one north of Milford, I don't recall that we ever received a letter from the Department of Ag about the outcome of that one. And I think they're supposed to send us a letter. I believe the same thing was true with the E5 and E6. I think the time limit has expired for them to send us a letter on those two as well, so.
It is a little confusing. About lines, and it says that after construction, they'll look at it again.
so is it that they won't know until it's constructed whether
Yeah.
it needs to?
That don't make sense.
It says in the letter that they should not begin construction.
Yeah.
I mean, to me, that's
And maybe it's just something on their plan that needs to be revised, as far as how it's being built or where,
I don't think they can say that. I don't know, I just, want to make everybody aware of what's going on,
Or what's not done.
or what's not going on. Exactly.
Yes, I noticed it. It's very noticeable.
You're not a character right now.
Okay, while Marvin's reading that, we can move to the next item, which is Illinois Senate Bill 75, which has to do with the training for sexual harassment. That's supposed to be a program or plan in place by January 1st of 2020. We were made aware that our liability insurance carrier, Bush McKnight agents, can give us provide us with that training, and I believe it won't cost us anything. We were hoping that Myron Munyon could be here today to talk to us about it, but I believe he's out of town. So we're gonna schedule him to come next month to talk to the committee. And at that time, if we're satisfied with everything that's related to them doing it, then we'll wanna make a motion to have them provide that training. The one question that I can have or see with it, the training has to be done once every year for everybody. So if they come here to do that, that's fine. But when there's a new hire, the new hire also has to get that training within 30 days of their hire date. I don't know that we can have them to come over here every time there's a new hire. So we may wanna make arrangements to have someone such as Amanda to be competent and trained to provide that training for the new hires. And have Bliss McKnight be the one to provide, but we need to work that out, I guess.
Could you have somebody videotape it and then play the videotape?
I'm not sure if that's acceptable. That's something we'll need to find out, but that's a possibility, so. It's just a matter that, apparently Bliss McKnight can provide the training, it won't cost us anything for them to do it, so it sounds like a win-win situation. But the issue about the new hires is something that we have to get worked out, so. So that's where that one's at. The next one we'll come to is the legalization of recreational marijuana. We've already passed a resolution about the sales tax on that. But we need to decide if we want to pass any kind of a ordinance or what have you regarding sales, growing it, or making products out of it, or nothing at all in the rural areas of the county. I understand that some of our people went to a seminar about that. Dee Shippert has some information that she'd like to tell us about. So I think we'll have her do that right now, if she's ready.
Okay, on October 22nd, Taylor and I went to a marijuana policy workshop in Buffalo Grove. The speakers were Joe McGuire, she's the executive director at the National Drug and Alcohol Screening Association, and William J. Judge, who is an Illinois-based attorney, and co-chairman of the Illinois State Chamber of Commerce Drug-Free Workplace Program. So they were pretty knowledgeable. The highlights that we took out of the meeting were that the most important thing is to have a policy in place. Once you have a policy in place, then you can protect yourself that way. But they were insistent that county employers should not be doing any drug testing unless there's a comprehensive policy in place. They talked a lot about, we're not talking about the same kind of marijuana today as, 20 years ago, or Woodstock, or any of that kind of stuff, that the THC levels, back then were like 13%, and they're like 300% increased. So it's not the same kind of marijuana that people grew up with. Some people grew up with. They said, do not implement a drug or alcohol testing program without a policy in place. That policies are living documents, and obviously you can change them at any time. But one of their big takeaway points was, if your policy, you do not want to have language in your policy that says stuff like under the influence or impaired at work, because you cannot prove an impairment. You will get sued and you will lose. What you need to decide is if you're going to have a drug-free policy, and then you can have put in your policy that if they have used drugs, then you're protected legally. They insist that counties use certified testing professionals. Obviously, it's a felony to try to cheat a drug test. To use correct testing products, no rapid testing, no hair testing, everything should be done by urinalysis. That every institution should have an MRO, a medical review officer, who determines the negative and positive test results, because levels that are under a cutoff level can also be caused from secondhand
Smoke.
exposure, yes. They said that that counties who have a highway department need a separate DOT and a non-DOT policy, because DOT policies are much stricter than for other county employees. They talked about a case that was Coates versus Dish Network. They had a man who had multiple sclerosis who had a medical authorization for marijuana, but because he was using that during working hours or coming to work under the influence of marijuana, the county fired him, or the company fired him, and he sued the company. The company actually won because they had a policy in place, the policy was clearly communicated, and the employee had signed it that he read the policy. And those are the three key things. They said, if you have a policy in place, that you communicate it, send it out in an email, here's your policy, and then the employee signs that they read that policy, that employers absolutely in Illinois, even with the legalization of marijuana, have a right to a drug-free workplace. So if they test positive, doesn't matter if they used it on the weekend or whatever. If they test positive, they have it in their system. You can say in your policy that you can't have it, that you have a drug-free policy. They can't have drugs in their system. So that was their big recommendation. They said that silence is implied consent. So if you do not have drug policy, you are implying to your people that it is okay to come to work under the influence of marijuana. Illinois rules, Illinois is going to be one of 19 states now with marijuana legalization, but the federal laws still apply to any federal workers. So under federal law, marijuana is still illegal and it's a Schedule I drug. So I specifically asked in that, I asked the attorney, this attorney has been doing this for 33 years. I specifically asked him, what happens with health department employees, for example, who work under a federal grant? Because some of our grants are state grants, some are federal grants. And he said if you are receiving salary reimbursement on those employees who are working under a federal grant, they have to follow federal rules. So the federal rules trump the state rules in those cases. So that was very clear. So those people have to be drug-free. They talked a little bit about employees who travel on the job. For example, all the health department employees are out in the community working. And if there's any kind of an accident, that you need to test all those around the accident for drugs to protect your workplace. That for new work comp regulations that will go into effect with this new Illinois policy, you've got to be able to prove that the person was not intoxicated or under the influence at the time of the accident. So you need to use those appropriate testing methods. For employees in a union reps can be present during the testing. They have a right to ask for a union rep to be present. They cited some key court cases, I won't go over those. They talked about CBD. CBD will not test positive. CBD is not what makes you high, it's the THC. There are 400 different testable components or compounds in a marijuana plant. So THC is what you're looking for. Illinois law 410 ILCS 130/40 says that you cannot discriminate against those people. So if someone comes to you upon hire and says, I smoke marijuana regularly. You cannot not hire them because of that. But if you've got a policy in place that says that you have a drug-free workplace, and the drug-free workplace policy is in effect, once that person after hire is tested and tests positive, as long as you communicated the policies in place, you communicated it to them and they've signed off that they've read it, you can then fire them. What you can prove is recent use, but the policy has to say use drugs, not impaired or any of those things that you can't prove. Status alone, you can't, like I said, you cannot not hire someone because they say they use marijuana, and unless doing so violates federal law or jeopardizes financial status or licensing under federal law. So for example, all the nurses carry nursing licenses in Illinois. They cannot work under the influence of drugs, so they, have to follow their licensing regulations. Once again, employees who work on federal grants are subject to federal laws. There is no cause of action if you have a no tolerance policy. You cannot be sued for letting someone go if you have an absolute no tolerance policy. So that's what they're recommending. The statute of reasonable suspicion is something more than a hunch. You have to have facts. You have to have heard, saw, smelled something, and took notes at the time that you had a reasonable suspicion to test someone. Okay?
Can I ask a question?
Yeah.
With myself, with the requirements because of the DOT, I can't, even though I might have reasonable suspicions, I still have to have a class. I had to take a class. I had to take a class, so I was qualified to make that call. Does that count for this too?
Well, so I asked that as well. So I said, so who, if you have reasonable suspicion, he said, well, if you have a nurse or a doctor associated with your agents, with your county, have a nurse or a doctor make that determination. Well, don't be sending the employees down to the health department, have my nurse to make that determination.
That's what I heard.
That's what I do.
No, I'm not gonna put them in that position. If you have reasonable suspicion, that's why you need this, what was it called, an something. An MRO, medical review officer. So the county needs a medical review officer. My suggestion for a medical review officer would be use IMH, or something like that. Because, yeah, that's my suggestion. But he's absolutely right. And I'm no expert on this. I went to a 4-hour class, so I'm no expert. But this is the information that they asked me to pass on. Let's see. Your policy should say any drugs. You should never use the word illegal drugs, prescription drugs, or synthetic drugs, or any drugs. That way you're covered. A big one, drug testing needs to go in a separate file and cannot be placed in an employee's file. There's a new law that came about under this new marijuana law. There's someplace in all that big document. They said that drug testing cannot go into an employee file. It has to go into a separate file. And even if the person has a medical prescription for the use of some drugs, that does not apply to the use of those lawful products which impairs an employee's ability to perform the employee's assigned duties. So as long as that statement is in your policy, you should be covered. So they gave us, written by attorneys, sample company policies that would apply to, that we can look at. To be honest with you, I glanced through them. I haven't read them through word for word. I thought I'd read them next week. I'll give them to Jim Devine, let him look at them, he can use those for a template or change up whatever he thinks is appropriate, but they were, most important things are, you've got to have a policy in place, you've got to communicate it to your employees, and the employees have to sign that they have read it. If you have those three things in place and you fire someone because they were under the influence, you should be covered.
So if someone has a prescription from a doctor for painkillers or something, is this going to be an excuse for them to not come to work because they can't come under the influence?
Okay, so we asked that question too, and the way it was explained to us is, that's why you you need a medical review, that medical MRO, medical review officer. Because a medical review officer will determine test results. So once that person tests positive, because you can't discriminate against them, so you just because they tell you they're using, you can't fire them for that, okay? You have to have a test. You have to test positive. So if they test positive of something, and they're under the influence of something, then that medical review officer, a doctor or a nurse, could make the determination of whether or not that person was able to perform their duties under the influence of that drug. But that's a sticky situation.
So are they better off?
You're better off having a no tolerance policy, period.
All right,
You know.
but the employee,
Mhm.
if they're not sure if it's still in their system, are they better off getting drug tested before they come back to work?
I don't know. I think this is more for, not for people who are, on a pain pill. And, I think this is more,
But people can get awful loopy on
they
pain.
can, absolutely. But I think this is more for, these policies are written more for, drugs that, impair your cognitive ability to perform your job, which that could happen on a pain pill. So I don't know. And then the other thing is you have to determine what you're gonna test for. If you're gonna test for all, what kind of panel you're gonna run. Are you only gonna do a panel on illegal drugs, or are you gonna do a panel on all drugs? What kind of testing are you gonna have? So, this goes for drugs and alcohol. So they gave these sample ones, and I'll read them, I'll give them to Jim, let Jim make that determination, and we'll kind of go from there, but it sounds like whatever your policy says, it needs to say, that you're a drug-free workplace, and that you have no tolerance policy. Otherwise, you're gonna get stuck letting people who are impaired being able to work, and that's not a good thing. Especially if they're out driving and.
Be curious to find out what it does for EMT. We have a IDPH license way further down than a nurse, but still an IDPH license.
Yeah. But they said as long as you have a no tolerance policy that says drug use, not impairment, because you can't determine that. And as long as you have the policy in place and it's been approved by the board, it's been communicated to the employees, and the employees have signed that they read it, should be okay.
It's almost gotta say it legal though, doesn't it? I mean, people take prescriptions.
No, you can have it to where you can do the panel for all drugs, and you can do differentiation according to what the penalties are if they come back positive. If it's a prescription drug, you can, if it's the painkiller and it's prescribed, you can maybe let them off with a warning because you shouldn't come to work when you're on this stuff. But if it's an illegal or it's a prescription drug that they don't have a prescription for, then it's on an automatic termination.
Yeah, exactly.
So what happens if Charlie's on pain medication because he got his knee done and comes to one of the board meetings and somebody that doesn't like him complains? He's technically an employee.
Almost seems like there's some HIPAA things here that, like, you know?
Yeah. So we talked a little bit about that, because I said, you know, what my question to the attorney was, a lot of people won't fess that up. They're not just gonna volunteer that information to you, so you're not gonna know that. So they said, well, then that goes back to reasonable suspicion, you know? So you have to, you know, if you reasonably, okay, so I use this for an example. This was the question I asked the guy. So when I was the school nurse, the teachers that thought the kids were high would send them down to the nurse's room, right? The nurse would look at them, you know, if they had dilated pupils, dry mucous membranes, flushed skin, rapid heart rate, you know, all those things that would indicate that they're under the influence of something. You know, that's when the nurse would say, yeah, I think they are, you know, and that's when a parent would get called, you know. But that's why I said, I don't want them coming down to the health department saying, have the nurse look at it, at them, because I don't want them making that determination, because you can have a hot flash and have those symptoms, you know? You know, so it needs to be a licensed professional who is, used to dealing with this kind of stuff.
And that's a good point, Lyle, like somebody has knee surgery or something like that, you have to have painkillers to get through.
Right, and
I bet
chances
you
are,
haven't had knee surgery.
that wouldn't be an issue. I'm guessing that wouldn't be an issue, because somebody who's had knee surgery is probably not going to be operating, you know, heavy equipment or anyway, until they're released from the doctor. So like, for example, if I have somebody at the health department who's on medical leave, I'm gonna make sure that that person has a doctor's note that says that they may return to work. You know, and if I ask them, you know, are you still taking a lot of pain medicine? Would, you know, I don't want to put you out on the road, we'll have somebody else do that. I mean, that's something that you can work out internally, I think. I don't think that should be an issue. I think the issue will be the illegal stuff.
Also, Charlie will have a prescription, I would think,
Right.
so that shouldn't.
But
You
even
don't know
with
Charlie
fifteen
very
miles
well.
driving.
But I think that's the main thing is
Huh?
having that doctor's release.
You don't know Charlie very well.
Basically, they're getting released to either with
Got
Richard
two knee
or
hips,
without.
now you're working on the knees.
Doctor's orders, they can still be on those medications for a reasonable amount of time afterwards.
Right, but you still have a medical professional saying, okay, they are prescribed this, they're on this, but
They may
my
return to
belief
work.
they may
Go home.
return to work.
Yeah.
But I've got a situation, and I know what I have in my little world is,
I come right straight
I don't
into
know if I would
a
necessarily want one of my dispatchers being under the influence of X, Y, Z, and actually, and legitimately having somebody's life in their hands.
Well, the
Trying to
thing
make
about
ultimate
that is,
decisions.
in the state of Illinois, a doctor's note trumps the employer's opinion. So if a doctor gives them a note that they may return to work, you have to let them return to work. You do not have a choice.
If I may make a suggestion as to how we might proceed with this, if you wanna forward your information over to Mr. Devine, I would suggest that maybe we ask him to look it over and maybe come to this committee meeting next month, because I think there's a lot of questions that he may wanna get some direction from us as to how we would like to have it written, or certain decisions about what goes in there and so forth. And so if we do that at this meeting next month, then it can be put together and approved at the December board meeting. So if everybody thinks that's a reasonable approach, I suggest we do it that way. The other thing is that what you're talking about is different than from what I initially started the subject with, and I think we need to recognize that we, as a board, need to decide what we're gonna do about marijuana activities in the rural areas of the county. We already passed a resolution about sales tax, but we still have the option to regulate sales and how that might occur. Are they gonna be licensed? Is it gonna be a zoning thing? What regulations apply to that? What people that might wanna grow it? What do we wanna do about that? Or somebody that's making any of the products from the plants, what we would wanna do about any of that. So those are things that we need to think about. There's some ordinance that McGinnis had. I don't think he was able to be here today. I suggested maybe if he comes with his stuff at the December meeting, maybe we can get into this in a little more detail. But I think we need to be thinking about what areas we wanna cover going forward regarding the sales or the use of the marijuana in the rural areas. Okay? So we
Would
need
that-
to do that, and we need to do what Dee has talked about as far as the policy for our employees here of the county.
Would that also need to somehow cover industrial hemp if a farmer wanted to grow that, or?
No, that's again something that we need to make decisions about. I'm told there's an awful lot of it growing in the county right now, so I don't know that we wanna necessarily delve into that, but maybe we do.
Well, I mean, if we're regulating the plants or whatever, then we need to, I guess, exclude industrial from any regulation or whatever.
Again, I think if we have him come here with what he has, that can serve as a starting point for us. When I talked with him earlier this week, he mentioned about, that we need to decide about these different areas, if that's what we wanna address. Maybe we wanna address all of them. It would seem to me that might be a good place to start. And if for some reason we decide that we wanna ban somebody from making any products out of it in the county, we could do that, or whatever. But if we wanna allow people to sell it in the county, if we wanna allow people to grow it or make products out of it, we need to have something in place to govern that. So that's kind of where we're at with that part of it. Okay? So I think we wanna look at that in the December meeting also. So in the meantime, if anybody has any information about any of those things, any ideas or thoughts, get them put together so we can cover them then. So we'll move on to appointments. I'm gonna have one appointment that I wanna bring before the board. That would be Dr. Rodney Alford to be appointed to the 708 board to replace Harry Shippert. And that term expires on June 30th of 2020. So I'll be taking care of that.
June 20th?
June
or
30th,
January?
did I say 20th? I'm sorry.
January or June?
June.
January.
The term expires June 30th, 2020.
You have to,
Oh, so they're resigning and you're replacing them in the.
Harry Shippert has already resigned.
Okay, so
we're
this person will just
gonna
fill out the
replace
term.
Dr. Alford to that vacancy. Okay, we got some correspondence to look at. This is not the same outfit that sent us the invoice, but it's another outfit that has some stuff to do. They're auctioning off farmland. They wanna know if we wanna auction off our farmland. There's the Friends of the Kankakee. They send us stuff all the time. This is from UCCI.
That's our kid.
Okay, next we come to the claims. You have a list of the claims in front of you.
Motion to approve.
Second.
Are there any questions or comments about the claims? I thought surely somebody might have one about one of those items, but I guess not. Call the roll, please.
Aaron's,
Yes.
Alt,
Yes.
Awful, yes, Sticknot,
Yes.
Sure,
Okay, old business. Is there any old business to come before the committee this morning? Is there any new business?
I would like to have the finance committee look at possibility of taking any leftover funds, especially in the contingency fund, and having anything left there as of November 27th be transferred to pay down the efficiencies bill, the loan for the efficiencies that we've done.
Okay, so you're recommending we do that? Have the
Yes.
finance committee do that?
Yeah.
Okay, sounds good to me. Anybody have any questions about that?
You have any figures in mind?
Currently, there's still the full 50,000 in there.
How much? Currently, there's 50,000 yet, so unless something comes in between now and then. If something does, that's why the date of the 27th, that way.
11/27.
Yeah.
We'll have Amanda and Joe make sure that gets on the agenda for the finance committee.
Is this like what? Project finished?
I believe it is. The only thing might be if there was, or if there's a little bit of lighting or something at the courthouse.
Some of those lights, they were having a hard time getting them, so I'm not sure if they've gotten them yet either. You can feel how much warmer it is in here today, right?
Didn't feel it.
You don't feel anything? What are you on?
Don't tell the
No
health
pain.
department, don't tell the health department. I lost my knees in here a little while ago.
So, now it feels warmer in there because I turned the thermostat on
Oh.
before the meeting. Okay, I think that takes care of everything. Is there a motion to adjourn?
So moved.
Is there a second?
Second.
Second by Mr. Barron. All in favor, aye?
Aye.
All the same side, we're adjourned.
What are you on?